Good evening, everybody. Today, the time is 6:02 p.m., so we're going to begin our remedial session now. The remedial session will be on the examination paper on match code practice. That is all we are here for. We are not here to answer administrative questions. The administrative questions, you must consult your learner guide, and if you don't find the answer, then you must contact your coordinator. So today we are going through the exam paper. What am I going to do? I'm going to point out the common mistakes students made when they answered the examination questions. The first question was, asked you to draft a particulars of claim. In the question, there was also a close corporation involved. So we looked out whether you cited the juristic person correctly. I would say 90% of the students cited the juristic person correctly. Okay, so we won't go through the particulars of claim in detail, but I'll point out to you the common mistakes made or things that you omitted in your answer. The first thing I want to tell you is the oral agreement. So there is no annexure with regard to the agreement because the agreement was oral. But if it was a written agreement, you were expected in terms of the match code practice rules to annex the written agreement. The next thing that was expected of you was you had to mention the fact that the second defendant executed a deed of suretyship, because that was a part of the facts that was provided to you. Okay, you also had to attach the suretyship, because a valid suretyship must be a written suretyship. That's the first two things I need to point out to you. Okay, let's just go to the next slide. Another common mistake was the memo says a notice in terms of section 129 of the National Credit Act. Okay, but you got the mark even though you only mentioned a letter of demand. But lots of students sent the letter of demand to a defendant. But remember, in this matter, there were two defendants, the juristic person and the natural person. So you should have had a copy of the notice and proof of posting, and should have been annexed. So a copy of the letter of demand addressed to the first defendant plus the proof of postage, and a copy of the letter of demand addressed to the second defendant plus the proof of postage. What I've also noticed is that some of the candidates, they actually cancelled the agreement. You could not cancel the agreement and then demand the defendants perform in terms of the agreement. So that was a mistake. There's no cancellation valid here in this particulars of claim because you want your money. If you cancel the contract, then what must happen? Restitution must take place. And there's not restitution, pay your money back. But if you proceed with the action, that is what you are praying for. The next common mistake was the plaintiff prays for judgment. Remember, there were two defendants, so you had to pray for judgment against both the first and the second defendants, jointly and severally, the one paying, the other to be absolved. So that was the, before your prayers, I don't know, what's the name? I'll tell you the word just now. What is this paragraph called? The preamble to the prayers. The plaintiff prays for judgment. The preamble starts from the word against. the other to be absolved. That is your preamble to your prayers. Then it was your prayers, which most students answered adequately. But when they claimed interest, some of them did not put a period or a time from when interest became claimable. Some of them said from 1 November 2015. When you claim interest, you always claim from this date to date of final payment. Okay, so that was another omission by students. I think that is all I have to point out to you in relation to the particulars of claim. A portion of my particulars of claim is cut off. Let me just go. Let me just have a look. A section of the particulars of claim is not here, but remember, a pleading, you draft a pleading because it goes somewhere. It's not there to lay on your desk. So your particulars of claim will go to the defendant. Okay? So let's move on to question number 2. Question 2A. Most of the students got this question wrong, because you can make an application for the liquidation of a close corporation in the magistrate's court, as well you can make it in the district magistrate's court and in the regional magistrate's court. You cannot liquidate a company in a magistrate's court, whether it's district or regional. So the correct answer would have been a yes to question 2A. With regard to question 2B, most of the students got that question also wrong because their answer was a no. Note the content of the question. The question says a curator ad litem. You can apply for the appointment of a curator ad litem in the district and in the regional magistrates court. You cannot apply for the appointment of a curator bonus in any magistrates court. A curator bonus application must be lodged in the High Court, not in the Match Court. Most students got this question correct. Okay. You cannot sequestrate an individual. The magistrates court, whether regional or district, cannot sequestrate an individual. You must apply for the sequestration of an individual in the High Court. Why is that so? Because it affects the individual's status. So you can apply for the liquidation of a close corporation in any magistrate's court, but you cannot apply for the sequestration of an individual in a magistrate's court, nor can you apply for the liquidation of a company in a magistrate's court. You must go to the High Court. Can you apply for ejectment in a magistrate's court? Yes, most students got that answer correct. Okay, an action for the delivery of goods valued at 150,000 rand. There, you were required to know the monetary jurisdiction of the district magistrate's court. So 150,000 rand falls within the monetary jurisdiction of the district magistrate's court. The students did not have a problem with this question. They, however, had a problem with 2A, 2B, and 2C. Most students got A and B wrong. So this is question 3. What procedure? Judgment was obtained against the plaintiff. The plaintiff owned no assets, but he was employed and he was earning a good salary. The defendant lives and works in Johannesburg. Okay, so remember, jurisdiction in a normal civil matter is dependent on place where the defendant is resident or the place where the defendant is employed. Here, your client obtained judgment in Durban, but the defendant has moved and works and lives in Joburg. So to enforce the judgment, he has to go to the court within which area of jurisdiction the defendant either lives or either works. So he has to go to the Joburg court. The memorandum says that the plaintiff would proceed in terms of Section 65. Another option plaintiff also has is to make an application for an emoluments order. Okay, so the memo says Section 65. Okay, but if you answered make an application for an emoluments order, the examiner also gave you the mark that was allocated to this part of the question. For the plaintiff to proceed, the plaintiff is your client, to proceed in the Johannesburg court, you would have to obtain a certified copy of the judgment that was granted in the Durban court. Okay, so a certified copy of the Durban court's judgment, and then he has to proceed out of the Johannesburg court. Why? Because the defendant lives and works in Johannesburg. The plaintiff could proceed in terms of Section 65 inquiry, or plaintiff could make an application for an emoluments order against the salary of the defendant. The emoluments order would instruct the employer to first pay a certain amount to the plaintiff or the plaintiff's attorney, and the balance he will give to the defendant. Let's go to 2B. You discovered that the defendant has a fixed deposit at ABC Bank. What procedure would you follow to secure the monies held at the bank? So here, it is not the emoluments order. The emoluments order is relevant to the employer. E for emolument, E for employer. Okay, here you would proceed to obtain a garnishee order instructing ABC Bank, the court instructing ABC Bank to pay you the money that the defendant owes you. The defendant has other judgments against you for a total amount. He cannot satisfy them all immediately. What procedures are available to him? So either you can have an administration order, or the defendant can apply to be placed under L.E.A.D review. Some students say apply for the sequestration of the defendant, but it's always better to first make use of other options before you go the very serious route of sequestration, because sequestration has serious consequences on any person's life. Okay? Let's see. To be again. Explain to be again.
Do whatever we want with whoever you want is none of my business. Now,
okay, let me go back to 2B again. I've got a request to go back to 2B. Okay. An application for the appointment of a curator at L.E.A.D. Okay, the question is, does the district magistrate's court have jurisdiction in the following matters? An application for the appointment of a curator at L.E.A.D. That is a Latin term. What does it mean? It means you are applying to have somebody speak on your behalf. Okay, so I am not compos mentis. I do not have the ability to place my case before the court, and an application is made for a curator to speak on my behalf during that court hearing. Then you have another type of curator. That is called a curator bonis. Bonis means goods, property. So you can have a curator appointed to speak on behalf of a person
Out of curiosity, why
who
would
will
I
not fully understand the court proceedings. Or you
so
can make an application
not
to
know
appoint a curator
things?
to take control of a person's property and his assets.
And the vanango ikatarara se yakadaro apa unoona kuti midnight dandarara
You can apply to the magistrate's court, whether district or regional, for the appointment of a curator ad litem. That is a curator who will speak on behalf of a person. But when you
I know zvangu back then I used to trek
want to appoint a curator to take control of a person's assets and money, then that one person is called a curator bonus. And the magistrate's court does not have
yazvinenzika pakangozi
jurisdiction
rakere
to listen to that matter.
no need hazvikoneki hazviitesani and ini ndakangozvidza kuti
Okay. So the magistrate's court can hear a matter in regard to a curator ad litem.
azvikandaika mupanika ndovana mudai wadzoka
The magistrate's court does not have the jurisdiction to hear and entertain a matter to appoint a curator bonus.
to know exactly kuti munhu ari kufungewa
Okay, so
angangonyuka
I hope you understand it now. If you don't, you can send me another note. Can we just, I'm just going to have a break for 1 minute. And I'll be back. Thank you.
hanzi no ndati pane dhiri remari chindogona kuwana maus dollar kana uchiwanawo mabhaya unenge uchipesawo kamakapu kako pandogona kutowana akawanda 500 to 1000 chiende inangu handa kumaandastimata because ndakangoziva kuti habe kumahotera obvious because anonzi taku wacho kamuzimba mufesiso mufundisa anonhingirina anosenza kuhotera ndii manager aitombosenza pasouthern apa anonhingirina anotomuziva anofanira kuva achimuziva but akachinja ako aritambo manje anonzi maziya matourist kane vaya vanongoita overnight chichande saka zvekuti anoona ma1000 anombozvidispita because ichi I think takwacho ndofunga akamuziva kuti ano totombosvika kana 1000 anoda unhingirina but chinozongonetsa pamwe mari inenge ite isipo 101 saka ndovana kuti zvangu hano ichi its bo ndovana muda hano inini chi kana uchidhila hako zemari kana uchidhila nagrace andizika weza anga kumenshina kuti grace chichichi chandizika ndokugona kupaina grace indoti iyo nagrace itai zvinhu zvi because ina anoda kumupa impression yekuti tikuziva zviri kuitika pakukwereta zvikanzi futi ndatombomu ndikati angada kundidza kuti akandikweresa mari pane friend yanga ndikati dhilai mega ikoko andizika because ina handii zvinozoti kana manetsana mangwanaka woda kundiinvhovha andizika pedzera nai sekuwirirana kwamuri kuita sei kwamuri kuita ina handisi kuti usawirirana naye kana kuti chii ndiri kuti inini in as much as grace ari kukubatsira ndizika try to maintain that relationship in an open transparent because indoshayana nagrace full stop and ndindakakulingana nagrace full stop watizika ina handiti kuti grace azotanga kunditi mai vamwana wako chichandizika iwewe just do things above board handizika nagrace kana wamuti uchamupa mari yake musi wakati mari yake musi watese waprofita because ini zvekuti azotanga kutsamwa kana kuti azondiinvhovha ina handidi.
Okay, I'm back again, so let's go back to question 3. Okay, I've done question 3. Let's go to question 4. Okay, this is about Fatima Khan. Judgment was granted against her, and she wasn't aware of the judgment until the sheriff came to her workplace with a warrant of execution. She tried to contact the plaintiff who got judgment against her, but she was unable to contact him. She then approached you to apply for rescission of judgment. Okay, I want you to take note. I want you to take note of the judgment was granted on 15 August 2015. Okay, 15 August 2015. The first time she became aware of the judgment was 1 September 2015. The application for the rescission of the default judgment was issued on 15 January. So we're talking about 5 months after judgment was granted. She lodged an application for the rescission of the judgment about 5 months after judgment was granted. Okay? She became aware of the judgment about 15 days after judgment was granted. Now, what does the rule say? The rule says that you must lodge an application for a rescission of a judgment within 20 days of the date on which you became aware of the judgment. So she became aware of the judgment on 1 September 2015. The application was lodged on 15 January 2016. Okay, so September. More than 3 months later, the application was lodged. So she is late with the application for rescission of judgment. The 20 days has long passed since 1 September. What is the question asked you to do? The question asks you to draft a notice of motion. The question goes further and say the short form of notice will be accepted. The question says omit any affidavits. So as you've been informed, there is 2 ways that you use to lodge a court case. The one is by way of action, the other one is by way of application. An action, you use a summons with or without a particulars of claim. An application, you use a notice of motion and a founding affidavit. The question tells you omit any affidavits, draft the notice of motion. The notice of motion is the document that contains the prayers you want the court to grant. The notice of motion does not contain the facts of the case that you set out in your founding affidavit. Most of the students who failed, what did they do? They drafted a notice of motion and they set out all the facts of the matter. Judgment was granted on that day. She became aware of the judgment on the other date when the sheriff served a warrant of execution. That must not be contained in the notice of motion. Those facts must be contained in the founding affidavit that you attach to the notice of motion. So most students got themselves a happy 1 or 2, some even got a 0 for this question. And that was the main contributing factor to the high failure rate in the match court practice exam paper. So what do you have before you? A notice of motion, okay? The notice of motion. Fatima Khan is the applicant. But in the main case, where judgment was granted against her, she was the defendant. Okay? Ronnie Govender, trading as clean wash, is the respondent in the matter because he is not lodging this application. Fatima Khan, the applicant, is lodging the application. But in the main action, Ronnie Govender was the plaintiff. So your notice of motion reads applicant/defendant. Ronnie Govender, respondent/plaintiff. Your notice of motion must have a title or a name contained within 2 double lines. Application for the rescission of a default judgment. Please take note, application will be made as the matter may be heard for an order in the following terms. An order in the following terms, the terms are your prayers. The terms are not the facts of the matter. The facts of the matter is contained in your founding affidavit. So I pointed out to you, judgment was granted in August. Fatima Khan became aware of it in 1 September, but the application only lodged in January of the following year. So she's long out of time. She wants the court to hear her application. So if she wants the court to hear her late application, she has to apply for condonation so that the applicant be granted condonation for the late filing of the application. That is all you say in your notice of motion about your condemnation, in your founding affidavit. That is why where you are going to explain to the court why are you late. You're not going to explain to the court why are you late in your notice of motion. That's not how it's done. What else does she want? Firstly, she wants the court to grant condemnation. Okay? That will always be your first prayer, because if the court doesn't grant the condemnation, the balance would not follow. So, you want, firstly, the court must grant you condemnation. That means they must listen to your application. Number two, you can ask that the default judgment be rescinded. You can't ask for the default judgment to be rescinded as number one, because the court will not listen to it until the court has granted the condemnation. So that is your first prayer. Then your second prayer will be that the judgment be rescinded. Okay? And then once the judgment is rescinded, what will happen next? If the court rescinds the judgment, it indirectly gives you the right to defend the action. So that follows the rescission. Alright? If you had it, if you were one of the few who actually did the notice of motion correctly and not set out the facts of the case in the notice of motion, and you had this not in the correct sequence, the markers nevertheless gave you the marks, even though it was not logical. Okay, so first the condemnation, you ask for condemnation, then you ask that the judgment be rescinded, and thereafter you ask that you be granted leave to defend the action. Okay, and then I think costs, and you offer that the respondent pays in the event of the application being opposed. Okay, and you ask that the plaintiff, I think it's Mr. Governor, pay the cost of the application if he opposes the application. Okay, so we are busy with a notice of motion and a founding affidavit. That is an application. Okay, and an application is opposed, not defended. Okay, so you couldn't say in the event that the action is defended. No, there's no action here. This is an application you're lodging. And then you also tell the court in your notice of motion whose affidavit will be attached to this notice of motion. So here the applicant is Fatima Khan, and therefore her affidavit is attached to this notice of motion in support of this notice of motion, dated, and it goes to the people. It doesn't lay on your desk. So do you understand that you cannot set out the facts of the matter in your notice of motion? The facts of the matter is set out in the attached founding affidavit or supporting affidavit. Question 5. Okay, lots of people got this question wrong. In a trial on the merits in the match court arising from a motor vehicle collision that occurred on that date, only the two drivers gave evidence. They give completely different versions as to the cause of the collision. The magistrate cannot decide which version to accept. Which judgment should he give, and what order as to costs should he give? Okay, so let's start at the beginning. If a plaintiff institute an action, the onus is on the plaintiff to prove that what he alleges is correct and is true. All right? So what happened here? In this scenario, what happened here? The plaintiff was unable to persuade the court that his version is the correct version and is most probably the true version. So the plaintiff did not discharge his onus. He made allegations. He had to prove to the court that his allegations was true and correct, and he failed to do that. That is why the magistrate should grant an order of absolution from the instance in favor of the defendant, number one. And number two, the plaintiff instituted an action. Because of his action, the defendant was forced to incur legal costs. Now they are on trial, and at the trial, the plaintiff is unable to prove his case. So, the plaintiff should be held liable for the legal costs the defendant was forced to incur because the plaintiff instituted an action that he cannot prove. The onus is on the plaintiff. He made the allegations. He failed to prove the allegations. So, the magistrate must grant an order of absolution from the instance. So, you can say the action, another word, plaintiff's action is dismissed with costs. That's a different way of stating absolution from the instance in favor of the defendant. You can say the plaintiff's action is dismissed with costs. So that means the plaintiff did not prove his case, and therefore the plaintiff is liable to pay the costs that the defendant had to incur to defend the action that was instituted by the plaintiff. Okay, so the question B, after the magistrate has given judgment, an independent witness who witnessed the collision comes forward and a statement supports the plaintiff's version. What action can the plaintiff take at this time? The plaintiff must issue a fresh summons. That was the answer, okay? The plaintiff cannot go back and recover the legal costs that was granted against him here. Because here he never proved his case. Maybe the plaintiff will be able to recover, get an order of cost against the defendant the second time around. But that will be on grounds of the fact that the plaintiff proved his case. That is why he can claim costs. He can't go back and recover these costs because he lost that case, because he didn't discharge his onus in this case. So what can the plaintiff do? Issue a fresh summons, and hopefully the plaintiff costs will be granted against the defendant in favor of the plaintiff. So what happens if the defendant doesn't defend the case here? Then plaintiff will be awarded costs, but on an undefended basis. What happens here if the defendant defends the case, but he loses the case, and the plaintiff discharges his onus and proves that the cause of the accident was the negligence of the defendant? Then the plaintiff may recover legal costs on a defended basis. So let's go to the next question. Okay, the next question is, you act for the defendant, advise what steps can be taken by the defendant in the following circumstances. The plaintiff is a foreigner and is concerned about recovering his costs if he successfully defends the action. Okay, you're acting for the defendant. The plaintiff is a peregrinus. The plaintiff is a foreigner. Your client, the defendant, is of the view that he has good merits to defend the case. You agree with the defendant, so you advise the defendant, yes, defend the action. But the plaintiff is a foreigner, and you are worried that if the defendant is successful with his defense, he won't be able to recover his costs. So what do you do to ensure that should the defendant be successful with his defense and the order of cost is granted against the plaintiff? You ask the plaintiff to give costs, security for costs. Okay? So you file a notice requesting security of costs. Question B, you act for the defendant. The plaintiff has applied for summary judgment. what two options are available to the defendant to enable him to continue with his defense of the action?
I've actually asked this to Patrick, asking to give me the copies of all the couriers.
What can the defendant do
Okay? I'm quickly going to type
to enable him to continue
and then we can
with his defense of the action? He can give security to the plaintiff to the satisfaction of the clerk of the court.
going with all the
Okay, that is half of the answer.
He was running around.
The other part of the answer is he must give security or any judgment that the court might give against him, plus the legal costs that might be incurred.
thing we're having
Okay, so he must give security to the plaintiff
now when we're having something like
or any judgment plus legal costs. A lot of students said give security to the plaintiff.
and what to do.
They did not say for the judgment and for costs.
I've done this, but your dates for
That's number one. Number two,
time to which time? I've already
or he can file an opposing affidavit setting out his defense.
that is already done.
Here in this case, the court will decide whether the plaintiff's application for summary judgment must be dismissed. Okay, here the court will not decide. Here the defendant will just be allowed to defend the matter. With the affidavit, the court will decide, does the defendant really have a bona fide defense? C, the plaintiff's summons is vague and embarrassing. Lots of students said that file a special plea. You cannot file a special plea. If you look at the rules, it says clearly, where a pleading is vague and embarrassing, not only a summons, but where a pleading is vague and embarrassing, you must raise an exception. But before you raise the exception, you must first give the plaintiff notice to cure the defect. Okay? So you must give the plaintiff an opportunity to correct what is wrong. And if he doesn't do that, then you raise an exception.
That is money.
Okay, so another twofold answer, not a single answer.
Through what is standing at the back of Father, forgive for what they are doing.
The plaintiff is sued for damages to his vehicle as a result of a motor vehicle collision for 50,000. The defendant accepts that he was 50. Okay. The plaintiff has sued for damages to his vehicle as a result of a motor vehicle collision for 50,000 rand. So the plaintiff instituted action against the defendant, claiming 50,000 rand. The defendant accepts that he was 50% responsible for the collision and has 25,000 rand available to pay to the plaintiff. So what did some students, they said,
It's what is the right word? I just want to say
some students said, apply apportionment of damages. Applying apportionment of damages means you carrying on with litigation. Okay? Litigation takes time. Litigation costs money. The rules of the court gives you another avenue to explore. That is Rule 18.2. Make an offer of settlement. And it's an offer of settlement without prejudice. So, this offer that you're going to make in terms of Rule 18.2 will not be divulged to the court if litigation proceeds. Okay? If the plaintiff does not accept your without prejudice offer in terms of Rule 18.2, the plaintiff is not allowed to divulge your without prejudice offer to the court. If he decides not to accept your offer, the offer can only be made known to the court after the court has granted judgment. Okay? So Rule 18 gives you another avenue to avoid further long-term litigation and to avoid incurring further legal costs. So that is your first option. You are going to make the offer first. That is the better route to follow than to file a notice of intention to defend, plea and counterclaim. And in your plea, you plead apportionment. That is the long road to take. This is a much quicker route to bring an end to litigation. So this is what your answer should have been. So make an offer in terms of Rule 18.2. Okay, so let me just do a little bit of explanation in regard to Rule 18.2. You, the defendant, makes the offer of 25,000 Rand. He makes the offer in terms of Rule 18.2. What happens if the plaintiff does not accept his offer and the whole matter goes all the way and goes to trial? Assume that at the trial, the court gives judgment. The court applies apportionment. The court applies the apportionment and gives judgment in favor of the plaintiff, 60-40, let's say 60-40. So the court gave judgment against the plaintiff, in favor of the plaintiff, that the defendant was liable for damage 40,000 Rand and the plaintiff was liable for damage 10,000 Rand. Okay, so the defendant must pay the plaintiff 40,000 Rand. The defendant made an offer of 25,000 Rand. In this case, legal costs will be decided solely by the court. Okay, the rules is not relevant. What happens if the court gives judgment in accordance with the offer that was made by the defendant? The court says each party was 50% responsible for the motor vehicle collision. In that case, then all the legal costs that was incurred by the defendant after he made this offer must be paid by the plaintiff. Because if the plaintiff accepted this offer at this stage, then the defendant would not have incurred the additional legal costs he incurred after making the offer. So in real life, you must give serious consideration to any without prejudice offer made in terms of Rule 18.2. Because if you don't accept the offer and the court gives a judgment that is less in favor of your client, then your client will be held liable for payment of all the costs the opposite party incurred after the opposite party made this offer. So be careful about just rejecting any offer made in terms of Rule 18.2. The same avenue is available in the High Court. Okay. Question E. The plaintiff issued summons for damages to his vehicle as a result of the collision. The defendant believes that he has a good defense and his vehicle was also damaged. When should he file his counterclaim? The counterclaim must be filed simultaneously with the filing of the plea. That is when you file your counterclaim. Some students also answered in regard to the DAs. He must file his counterclaim within 20 days after he served his notice of intention to defend. A mark was also given to you because your answer was not incorrect. Is that all? Okay, let me just go to the questions. Here's a question. Please explain why you use the word defend in C and say it cannot be used under D. Okay, so let me just go back and see which question are you referring to. D is? Let me just find it. Let's see.
Yeah, yeah, that page, the previous page and this one. Yeah, that page, man. That
There's a question here by Sebolelo Ingrid. Please explain why you use the word defend in C and say it cannot be used under D. Can you tell me which question are you referring? Are you referring to question 6?
question 4. Question 4.
Question 4. Okay, I think you are talking about the notice of motion. So that the applicant defendant be granted leave to defend the action. And then that's C, which is correct. The applicant defendant be granted leave to defend the action. Now let me look at D. That the respondent plaintiff pays the cost of the application in the event of the application being opposed. Please explain why you use the word defend in C and say it cannot be used under D. The word defend is not relevant to D because D refers to the plaintiff respondent, okay? C refers to the applicant defendant. So we're talking about two different people. Why would the applicant defendant, who is Fatima Khan, why would Fatima Khan ask the court to give an order of cost against herself? Okay? That is the one question. So now I'm going to the next question. Please explain when you use garnish order and when you use emolument order. Okay? That can be confusing. But how do I remember why do you use an emolument order and not a garnish order? I remember that because emolument order starts with the word E and employer starts with the word E. So that is how I remind myself. When would I use an emolument order? An emolument order is always granted by the court against an employer. Okay? Emolument order against an employer. The court instructs the employer, before you pay Jack Jones his salary, you must first pay Dilshaad Gani 100 Rand every month or every week. Then what is left of Jack Jones's salary, you can pay to him. Okay? So that is emolument order and employer. Ganishi order is, I owe Jack Jones 10,000 Rand. I owe Jack Jones 10,000 Rand. Jack Jones finds out that I have 20,000 Rand in my bank account. There's no employer involved, okay? So what does Jack Jones do? Jack Jones goes to court, tells the court I owe him 10,000 Rand. And he has proof that I've got 20,000 Rand in Absa Bank. So then he asks the court for an order instructing Absa Bank to take 10,000 Rand and pay him the 10,000 Rand that I owe him. Okay, another example. I don't think my example was good. Because whatever is in your banking account is supposed to be confidential. I am a holder. I owe Jack Jones 10,000 Rand. I am holding a shopping complex in Sunnyside. Jack Jones finds out I am building a shopping complex in Sunnyside. He finds out more information, and he also finds out that once the building reaches a certain stage, the person who I am building for is supposed to pay me 50,000 rand. Jack Jones goes to court, and Jack Jones tells the court about the building I'm building in Sunnyside and the contract I entered into. And he tells the court that when the building reaches roof height, then the owners of the Sunnyside building will pay me 50,000 rand. So Jack Jones asks the court for an order that the owners of the building, when the building reaches roof height, the owners of the building must first pay him 10,000 rand, and then they can pay the balance of 40,000 rand to me. So once again, with regard to the bank and with regard to the building, there is no employer-employee relationship. Okay, I am building a building, but I don't work for the owners of the Sunnyside building. I am an independent contractor. Okay, so how do I remember when do you use an emolument order and when do you use a garnish order? I remind myself by noting emoluments order starts with an E and the word employer starts with an E. So that's why I will not make that mistake. Okay, I hope that. I hope that you will remember that. Okay, somebody's asking, can you please the difference between there's something some say 15. Here's a question about the interest rate claimed by. I don't know about who. Oh, the particulars of claim. The interest rate. I think the current interest rate is 10.25. Okay? That is irrelevant with regard to question 1. Why is it irrelevant? Because the contract, the agreement determines the interest rate. The fact that the current interest rate is 10.25 is irrelevant to this contract. Why is it irrelevant? Because the parties who entered into the agreement agreed on an interest rate of 15%. If there was no interest rate agreed on in this agreement, then you would default to 10.25. Okay? So here we use 15% in the memo because that is what the contract stipulates. If the contract was silent, it would be different. If the contract said 20%, your particulars of claim should have claimed 20%. If the contract said 5%, your particulars of claim should have claimed 5%, not 10.25. Can you kindly go back to question 1? Okay, now. No, let me go back here. My question, you also said that you cannot defend, but you can only pass however you said two words in different. Okay, let me go to that question. Where's that question? Okay, it was application for rescission. Remember, there was an action, okay? The action was concluded. How was the action concluded? The action was concluded when the court gave judgment. But now, the defendant in the main action wants to apply for the rescission of that judgment because judgment was granted without her knowledge, all right? So, without her knowledge means it's a default judgment. So, if you choose to, you can leave out the word defendant, if you left out the word defendant in the examination answer, you were not penalized for it. Okay? If you choose to, you could refer to Ronnie Govender, who was the plaintiff in the main action, as only the respondent, if you choose to. You could have left out the word plaintiff. Okay? But this is an application. That is why you must use the words applicant and respondent. You cannot go in the application and say Fatima Khan, the defendant. Okay? We add the word defendant and we add the word plaintiff just for clarity and for the court not to go back and hunt for things. So when the court looks at your notice of motion, he will immediately know that Fatima Khan is the applicant in this application, but there was an action in which action Fatima Khan was the defendant. That's the only reason. All right? So let me look at the question. This is just for clarity. Okay? It's just for clarity that we add these two words. If you omit the words, it's okay. Okay, now you're telling me, can you kindly go back to question 1? Can you kindly go back to question 1? Tabile. Well, what about question 1? What is it you want me to clarify about question 1?
Yes, you are speaking to him.
Or do you want me to go back to question 1 because you came late? Okay, let me do question 1 quickly. What did we look out for in question 1? There was a juristic person involved, so we expected you to cite the juristic person correctly. Most people did that. I did not see an answer book where the juristic person was not cited correctly. Principal place of business was mentioned. We have a second defendant because the second defendant signed a suretyship. Okay, so we have the first defendant and we have a second defendant. It was required of you to have two defendants in the case because of the facts that was placed before you. This is fine. It is just a repeat of what was in the question. We expected you to mention that the second defendant executed a deed of suretyships. Okay, and we expected you to annex the suretyship because a legally valid suretyship must be in writing. So remember what the rule says? The rule says you must annex all documents to your claim, to your particulars of claim on which your case is based. So you instituted action against the second defendant on grounds of the suretyship that he signed. And what else is there? That was part of the facts that was given to you. That was part of the facts that was given to you. Okay? The plaintiff forwarded the notice. This is a section 1-2 notice. So if you answered, the plaintiff sent a letter of demand to the defendant. We accepted it and still gave you the mark, even though you didn't mention section 129 of the National Credit Act. Okay? The mistake made by a number of students was they sent a letter of demand or a section 129 notice to one defendant. Why would you do that? There's two defendants in the matter. So you had to send it to both defendants. All right? So that was a written document. So we expected you to annex the documents to your pleading. The other thing is some students cancel the contract. You can't cancel the contract. The next mistake was the preamble to the prayers. Some student prayed for judgment against the defendant. Again, there's two defendants. Just like you have to send the letter of demand to two defendants, you have to ask for judgment against two defendants. jointly and severally, the one to pay, the other to be absolved. So what does that mean? If defendant 1 pays the money, defendant 2 doesn't need to pay the money. Okay? So you're not entitled to 240 grand. The defendant, if the second defendant pays the money, the first defendant doesn't have to pay again the 120,000 rand. That is what it means when you say the one to pay, the other to be absolved. So if number 1 pays, number 2 is absolved from paying. If number 2 pays, number 1 is absolved from paying. All right? So everybody got this right. But then we came to the interest rate. 15%, because that is the terms of the agreement. Okay? It's the terms of the agreement. Interest at the rate of 15% per annum. You specify from when must they pay interest, until when can you claim the interest. So the payment was due on 30 or 31 October. So you pay interest from 1 November. Till when? Till death us to part? No. Till date of final payment. Okay? And you ask for cost of suit. And all pleadings must be signed. All pleadings must be dated. Okay, so do you have any more questions, or can we end the session? Okay, I'm getting thank yous. Thanks, answered. Okay, if you have any more questions, you can phone me tomorrow on 012-441-4648, but you have to phone before 10:45. Thank you.